EU law is an academic field in its own right. We focus on judicial politics in the EU, which lies in the intersect between EU law and political science. This means that we are mainly concerned with the relationship between political actors and how the law functions as a mean towards political ends. We start by noting that it is the rule of law that makes political decisions binding. The legal system with its judges at the helm are responsible for enforcing the rule of law. However, all laws and constitutions are incomplete contracts. By that we mean that all possible scenarios are not explicitly specified in the legal texts. The task for judges is to interpret the law in cases where the law is not clearly specified. The key assumption in judicial politics is that judges are not neutral actors. They have their own preferences, and law and constitutions are sufficiently incomplete to allow judges to act upon these preferences. To analyze the role of courts in the political system, we again turn to spatial models. In the judicial game, there are three institutional actors: the executive, the legislature, and the court. The figure shows a lineup of these actors along the relevant dimension. The court, C, is located towards the far left. The executive, E, is centrist. The legislator, L, is located to the right. Assume that the executive and legislature have agreed on a policy X. However, through judicial reviews and opinions on cases brought before it, the court is able to move the policy to Y. While the legislature is unhappy about the policy move from X to Y, the executive is indifferent as Y is equally far from the ideal point as X. However, if it's relatively cost-free for the executive to introduce new legislation, it can successfully propose its ideal point as the legislature prefers E to Y. As a result, the final policy is E. Moreover, the policy is stable at E, as the executive will reintroduce E whenever the courts try to move the policy towards C. From this simple game, we learn that the power of the court depends on the ability of other actors to introduce new legislation. That is, new legislation is capable of overturning the court's interpretation. More generally, the power of the court will also depend on the supply of court cases that the court can use to change policy. Also, information about the preference of the court may matter. If the legislator knows that the court has very different preferences, the scope for judicial drift might be limited when drafting the legislation. As a result, the power of the court may be strongest when there is little information about the preferences or the willingness to use court cases to change policy. Also, from this game we noted that the power of the court also depends on the ability of other actors to adopt new legislation. In bicameral systems, such as the EU, where multiple chambers have to agree in order to adopt new legislation, the court is empowered. It is because some of the actors whose support is needed in order to adopt new legislation might benefit from the court's judicial drift. In other words, provided that the court is strategic, it can be a major political actor. Until now, we have considered the court as a unitary actor. Note, however, that the legal system consists of a hierarchy of courts. The ability of the higher courts to act on its preference depends on the supply of cases from the lower courts. All courts in the judicial system may not share the same political or institutional preferences. Moreover, a court is a collective actor, just like a legislator. Judges might differ in their preference over individual cases, as well as the political implication of their rulings. Faced with the same evidence, judges might reach different conclusions. Hence, the composition of the court and the appointment of judges matter. Judicial appointments can be understood as a delegation within the principal-agent framework. However, the principal may care more about the competence of the judge than about the preferences. It is nevertheless unlikely that the executive does not take the preference of the judge into account when appointing judges. So there's a dilemma at heart of judicial politics. Constitutions, the rule of law, and independent courts are necessary for free citizens to reach collective agreements. However, judges are political actors, not neutral actors that just apply the law. Legislative majorities can limit the power of the courts by introducing new legislation to repeal court decisions. But this may undermine the whole legal system.